Hello friends, I Naushad Alam, LLM from Delhi University, a practicing advocate and currently associated with Delhi High Court Legal Service Committee, present a module titled Alternate Dispute Resolution, Lok Adalats and Other Mechanism. In this module, I shall be first giving you the historical perspective, and then I will be taking you through two important aspects, which are Lok Adalat and Gram Nyayalya. Historical perspectives. Article 39A of Constitution of India, which comes under the directive principle of state policy, envisages that state shall ensure that opportunity for securing justice are not denied to any citizen by reason of economic or other disabilities. Accordingly, Article 40 of the Constitution of India, which also comes under the directive principle of state policy, also envisages establishment of Gram Panchayat at grassroots level. Accordingly, Article 14 of the Constitution of India also envisages that a state shall not deny to any person equality before the law or the equal protection of the law within the territory of India, and it also envisages prohibition of discrimination on the ground of religion, race, caste, sex and place of birth. On this principle, on September 26, 1980, Committee for Implementation of Legal Aid Scheme CILAS to monitor and implement legal aid program on a uniform basis in all the state and the union territory was established. In this regard, first Lok Adalat was held in the year 1982 in Gujarat. Then accordingly, Legal Service Authority Act 1987 was enacted. After that, Legal Service Authority Amendment Act 1994 after that, Legal Service Authority Amendment Act 1994 was passed by the Parliament, making a provision for establishment of Lok Adalat and giving the Lok Adalat a statutory recognition. Accordingly, Constitutional 73rd Amendment was also passed by the Parliament, and which gives the way for the establishment of Gram Panchayat and Gram Nyayalya at the grassroots level. Object of Legal Service Authority Act and amendment made thereupon. The preamble of the Act states that it is to constitute legal services authorities to provide free and competent legal services to the weaker section of the society, to ensure that the opportunity for securing justice are not denied to any citizen by reason of economic or other disability, and to organize Lok Adalat to secure that the operation of the legal system promote justice on the basis of equal opportunity. Thus, the preamble of the Act itself says that there are two goals. First, to provide the legal aid to the needy person. The Act envisages the kind of person to which legal aid has to be provided. And secondly, the Act provides for establishment of Lok Adalat, meaning thereby a alternative dispute resolution mechanism has been given statutory recognition first time under this Legal Service Authority Act 1987. Section 2B of the Act, that is 1987 Act, says that Lok Adalat means Lok Adalat organized in accordance with Chapter 6 of the Act. The function of the central authority appointed under the Act inter alia includes encouraging the settlement of dispute through Lok Adalats and encourage the settlement of dispute by way of negotiation, arbitration and conciliation. Chapter 6 of the Act, Scheme and Definitions. Section 19 of the Act says that every state authority or the district authority or the Supreme Court Legal Services Committee or the every High Court Legal Services Committee, or as the case may be, Taluk Legal Service Committees may organize Lok Adalat at such intervals and place and for exercising such jurisdiction for such area as it thinks fit. It further provides for the qualification and manner and appointing authorities of the appointment of person to preside over the Lok Adalat. Act is having detailed scheme as to which kind of disputes may be taken up by the Lok Adalat and the person who will preside over the Lok Adalat for proper and amicable settlement of the dispute between the parties. Section 19(5) of the Act provides that Lok Adalat shall have jurisdiction to determine and to arrive at a compromise or settlement between the parties to a dispute in respect of any case pending before it or any matter which is falling within the jurisdiction of it or is brought before it any court for which the Lok Adalat is organized. Meaning thereby Lok Adalat can take up the case either if the party desire to do so or if the matter is referred by the court where the disputes are pending. However, it also provides that Lok Adalat shall not have jurisdiction in respect of any case or matter relating to any offence not compoundable under any law. Meaning thereby if the offence in any law is not compoundable and cannot be compromised between the party, then the Lok Adalat shall not have any jurisdiction to entertain that dispute and bring an amicable settlement. Section 20 of the Act provides for the Lok Adalat may take up the case falling under section 19(1) of the Act with the consent of the party, where the parties make an application to the court for referring the case to the Lok Adalat and court is prima facie satisfied that there is chance of settlement or the court is satisfied that matter is appropriate one to be taken cognizance by Lok Adalat. Meaning thereby there are 4 or 5 methods where the Lok Adalat can intervene, either with the consent of the party or if a party to a dispute in the court makes an application to the court that the matter may be referred to the Lok Adalat or the court is satisfied that the matter is fit to be referred to the Lok Adalat and matter may be taken cognizance of by the Lok Adalat, then the matter will be taken up by the Lok Adalat for amicable settlement. Section 23 provides that Lok Adalat shall proceed to dispose of the case or matter and arrive at a compromise or settlement between the party. Once the matter is referred to a Lok Adalat either by the parties or by the court, then the court shall proceed to dispose of the case or bring the party to an amicable settlement. Section 24 provides that every Lok Adalat shall, while determining any reference before it under this Act, with utmost expedition to arrive at a compromise or settlement between the parties and shall be guided by the principle of justice, equity, fair play and other legal principles. Thus, the technical law of evidence and the technical law of Code of Civil Procedure has been done away with and Lok Adalat has been given freedom to bring the party to a settlement in accordance with the justice, equity, fair play and etc. Section 25 subclause 5, Section 20 subclause 5, 6 and 7 in nutshell provides that if the party to a disputes are not coming to a common ground before the Lok Adalat and the process of settlement fails before the Lok Adalat, then the parties will be advised by the Lok Adalat to approach a court of law for matter getting adjudicated by the court of law. Thus, the parties are having options not to settle the matter before the Lok Adalat and seek the remedy before the court. However, in Lok Adalat the atmosphere is such that there is all likelihood that the matter will be settled by the Lok Adalat. Section 21 provides that every award of the Lok Adalat shall be deemed to be a degree of civil court and in any case cannot be challenged before any court of law. The reason and the logic behind this section is that the award passed by the Lok Adalat is passed with the consent of the parties, and if the parties are given opportunity or if the parties are given liberty to challenge that award, then the whole purpose of settling the dispute before the Lok Adalat gets vitiated. Thus, the award passed by the Lok Adalat is not open to challenge in any court of the law. Accordingly, also section 20 sub clause 1 provides that if the matter is settled through the Lok Adalat and the award is passed by the Lok Adalat, then the party to a dispute may approach to the court for refund of the court fee in terms of section 16 of Court Fees Act 1870. Thus, the expenditure made by the parties in the court to get the dispute adjudicated gets refunded by the court if the matter is settled with the intervention of the Lok Adalat. Section 22 vests the power of civil court before the Lok Adalat. However, there is a special situation. The power of civil court has been vested in the Lok Adalat, but Lok Adalat is not bounded to follow the strict principle of Code of Civil Procedure or strict principle of other law, and Lok Adalat is having liberty to decide the dispute according to justice and according to the practices and taking into consideration the social and economical consideration of the parties at dispute. This section, that is section 22, also provides that the proceeding before the Lok Adalat or permanent Lok Adalat, which I shall be discussing later on, shall be deemed to be a judicial proceeding within the meaning of section 193, 219 and 228 of Indian Penal Code. Part 2 of the Act, which deals with the permanent Lok Adalat. The special situation with the permanent Lok Adalat is that the party may approach the permanent Lok Adalat voluntarily for getting the dispute either settled or adjudicated. If the Lok Adalat has been approached by any of the parties to the dispute, then the party is having two options: either to get the dispute settled by a permanent Lok Adalat or to get the dispute adjudicated on merits. If the disputes are adjudicated on merits, then that award is final and binding and not generally amenable to challenge in the court of law, and the permanent Lok Adalat has been established throughout the country under this Act. Section 22 provides for the cognizance of case by the permanent Lok Adalat. Any party to a dispute may, before the dispute is brought before any court, make an application to the permanent Lok Adalat for the settlement of dispute, except the matter relating to an offence not compoundable under any law and where the value of the property in dispute exceeds 10 lakh rupees. This pecuniary jurisdiction may be increased by the central government by notification in consultation with the central authorities appointed under the Act. Thus, the salient feature of this section 22 is that parties are at liberty to approach permanent Lok Adalat. Thus, the central feature of this section 22 is that parties are at liberty to approach permanent Lok Adalat voluntarily, and if the permanent Lok Adalat is approached, then the other party shall not have any option but to get the matter adjudicated or settled with the intervention of the permanent Lok Adalat. Once the matter goes into the domain of permanent Lok Adalat, the outcome will be either settlement or adjudication. However, the permanent Lok Adalat shall not have power or is not having power to adjudicate the dispute or especially the dispute which are not compoundable under any law for the time being in force. The pecuniary jurisdiction of permanent Lok Adalat is generally 10 lakh rupees. However, the central government may by notification may increase this pecuniary jurisdiction. Section 22 provides that after an application is made to the permanent Lok Adalat, no party to that application shall invoke jurisdiction of any court in the same dispute. Thus, if you approach a permanent Lok Adalat, you later on cannot approach a court for the adjudication of dispute. Accordingly, section 22 subclause 3 provides that permanent Lok Adalat may ask the party to file written statement, documents stating therein the facts and nature of the dispute, and send a copy of such statement together with the copy of such document and other evidence, if any, to each parties. Meaning thereby party approaching to permanent Lok Adalat shall file his statement of claim supported by all documents and evidence and the permanent Lok Adalat is under obligation to send all those document, statement of claim and evidence to other party. After completion of these procedural formalities, permanent Lok Adalat is under obligation to conciliate, first facilitate the conciliation, then formulate a term of settlement, and after that decide the dispute either on merits and pass the award in terms thereof. Therefore, taking into consideration the claim and counter claim by the parties involved in the dispute, permanent Lok Adalat shall first dispute, after taking into consideration the claim, counter claim, evidence brought on record by the parties, permanent Lok Adalat is under obligation to facilitate conciliation between the parties, and the permanent Lok Adalat is after that will offer a formulate a term of settlement and give the term of settlement to the parties for their observation and comments. After that it may reformulate the term of settlement, and once again same exercise will be carried out. After that permanent Lok Adalat shall either pass an award in terms of settlement or pass an award in terms of merit of the case. Guiding principles before permanent Lok Adalat. Permanent Lok Adalat shall, while conducting conciliation proceeding or deciding a dispute on merits, is guided by principle of natural justice, objectivity, fair play, equity and other principle of justice, and shall not be bounded by Code of Civil Procedure or Indian Evidence Act, like is the case of Lok Adalat. And the award passed by the permanent Lok Adalat is binding on the parties or the person under claiming them. Permanent Lok Adalat is having power of civil court, it can call witness, it can summon document, it can summon official witness, etc., like a civil court does. And the proceeding before the permanent Lok Adalat, as is in the case of Lok Adalat, is a judicial proceeding as envisaged under Indian Penal Code. The award passed by the permanent Lok Adalat is executed or may be executed with the intervention of the civil court. In this section I will be dealing with Gram Nyayalayas Act 2008. In the introduction part I described in brief about Article 40, Directive Principle of State Policy, talking about establishment of Gram Panchayat, and Article 243A of Constitution of India brought into force by way of Constitutional 73rd Amendment in the year 1992. This act was passed in the year 2008 to give an enhancement to the concept of Gram Panchayat. This act in its preamble says that it is an attempt to establish Gram Nyayalayas at the grassroots level for the purpose of providing access to justice to citizens at their doorstep, and to ensure that opportunities for seeking justice are not denied to any citizen by reason of social, economical or other disabilities, and for that matter connected or incidental thereto. The Act under section 2B defines Gram Panchayat to be an institution of self-government. The Act under section 2B defines a Gram Panchayat to be an institution of self-government constituted at the village level under Article 243B of the Constitution of India. There are certain aspects to this establishment of Gram Nyayalaya which is also called village courts, because this matter primarily falls upon the state domain. However, the center is giving all assistance to the respective state for the establishment of Gram Nyayalayas or village courts, but the establishment of Gram Nyayalayas and village courts at the grassroots level is at present finds very few. Silent provision of the Act. Section 11 states that Gram Nyayalaya shall exercise both civil and criminal jurisdiction, and section 22 states that Gram Nyayalayas may take cognizance of an offence or a complaint or on a police report and try all offences specified in part 1 of the first schedule and try all offences and grant relief if any specified under the enactment including in part 2 of that schedule. Similarly, section 13 states that Gram Nyayalaya can try a suit and proceeding of a civil nature as specified in part 1 of the second schedule, meaning thereby Gram Nyayalaya, under the act Gram Nyayalaya has been given the power to adjudicate the civil and try the criminal offences both, and the category of the cases and the nature of the criminal dispute or criminal trial which may be taken cognizance by the Gram Nyayalayas has been specified under the act. However, the prime obligation is the prime obligation of the state to ensure the implementation of this act lies with the concerned state government. Central government is only providing assistance, mainly financial assistance, to the establishment of this Gram Nyayalaya at the grassroots level. Section 20 provides for the plea bargaining in accordance with the Code of Criminal Procedure. Thus, the Code of Criminal Procedure by the way of amendment in the year 2003 has given a concept of plea bargaining. However, the plea bargaining concept in India is a new kind of thing in the criminal justice system, and this 2008 Act also provides that Gram Nyayalaya shall have power to dispose of the criminal matter in terms of Code of Criminal Procedure, especially the plea bargaining provision. Section 22 states that judgment in every trial shall be pronounced by the Nyayadhikari immediately after the trial in open court or any time not exceeding 15 days. The time limit of trial of a criminal matter has been set in the act, and the time limit has been provided 15 days, meaning thereby time frame has been provided so that speedy justice are done at the grassroots level. Nyayadhikari who has to adjudicate the dispute or who has to try the criminal offences and envisaged under the act or the schedule thereof is appointed by concerned High Court. The qualification of the Nyayadhikari has also been provided under the act. ADR before the Nyayalayas. Section 26 states that Gram Nyayalaya shall assist party in arriving at a settlement in every suit or proceeding in respect of subject matter of a suit, claim or dispute. Gram Nyayalaya presided over by Nyayadhikari which is appointed by concerned High Court is having two sets of power, first to try the civil dispute and second to try the criminal dispute. In case of civil dispute, 60 days limitation has been provided that Gram Nyayalaya shall dispose of the civil matter within 60 days, and also in the case of criminal dispute Gram Nyayalaya shall dispose of the criminal trial within 15 days. Section 26 of the Act casts a duty upon Gram Nyayalaya to bring a party to amicable settlement in case there is a chance of settlement of a dispute before it. Thus, the prime objective of this Act first is to give the justice system adjudication at the grassroots level, and secondly cast a duty upon the Gram Nyayalaya to bring parties to a dispute to a amicable settlement by way of any of the method of alternate dispute resolution mechanism, which may be arbitration, conciliation, mediation or intervention of the Lok Adalat. And for that matter, Gram Nyayalaya is a primary organization which can be accessed by the person existing on the grassroots level for the adjudication of the dispute. It is quite difficult for a person at the grassroots level to travel a far distance, say at a district level, and to approach a court for the adjudication of the dispute. However, if the justice delivery system is provided at the grassroots level for the adjudication of the dispute or for the criminal trial of a small crime as envisaged under the Act, then this Act will give a criminal justice system, a fair play and a belief in the criminal justice system, as well as civil dispute delivery mechanism to the people at the grassroots level. The prime objective of this act, as envisaged under section 40, the prime objective of this act as envisaged under article 40 of the Constitution of India and also envisaged by way of 73rd amendment in the Constitution of India in the year 1992, is that grassroots level justice system is having an effective mechanism for the adjudication of a dispute which may not be decided or which is not in the interest to be decided by a court of competent law existing at a district level or even at a higher level. Thus, the summary of this module is that there are two mechanisms for the adjudication of dispute by Lok Adalat, with the intervention of Lok Adalat as appointed under the Legal Service Authority Act 1997 and with the intervention of Gram Nyayalya at the grassroots level. These two organizations is having power either to adjudicate the dispute or either to bring the party to a common settlement on the ground of conciliation, mediation, arbitration. Thus, these two acts give a force to alternative dispute resolution mechanism existing in India and bring the party to a settlement which is long lasting and which is not based on ego and adversarial process of court of law. Thank you.